Hi, I'm attorney Courtney Werning with the law firm of Meyer. For the last 10 years, I've been representing investors who have claims against their financial professionals, and I'm going to talk briefly about what happens at a securities arbitration hearing. Most customer complaints against financial or investment institutions are subject to mandatory arbitration. This means that a customer dispute is decided not by a judge or a jury, but instead by an arbitrator or panel of arbitrators who are appointed to decide these cases. While many of our cases settle prior to an arbitration hearing, sometimes the parties are not able to agree to a resolution. In that case, the parties present their claims and defenses to the arbitrators, and those arbitrators make a final decision. Kind of like a verdict, but it's called an arbitration award. While an arbitration hearing is a less formal setting than a court proceeding, the process itself very much resembles a trial that you've seen before on TV. Since the cases are not filed in court and not decided by a judge or a jury, they're not conducted in a courthouse, but instead in a conference room setting. Let's talk about the hearing itself. The parties, their counsel, and the arbitrators gather in the conference room. The lawyers for the parties have all of their exhibits and other materials that they intend to provide to the arbitration panel. The arbitration hearing begins with the lawyers for each side making opening statements, which are intended to give the lawyers an opportunity to summarize their client's case and what they intend to prove at the hearing. After opening statements, the claimant puts on what is called their case in chief, during which time the claimant's side calls witnesses to testify under oath. We'll call any number of witnesses, lay witnesses and expert witnesses, that we need to prove our case. Respondents' counsel will have an opportunity to cross-examine each of our witnesses, and once we're done putting on the claimant's case, the advisor or the firm can put on their defense. They put on their own witnesses, and we have the opportunity to cross-examine them and ask them questions. Typical witnesses in a securities case include the customer, the advisor's supervisors or compliance people, damages experts, and liability experts. Most of our law firm's arbitration hearings last about 3 to 5 days, but some more complex cases may last longer, like weeks. Throughout the arbitration hearing, the parties may object to particular evidence or lines of questioning, and the arbitrators must decide whether to sustain or overrule the objections. While the formal rules of evidence do not technically apply in arbitration, most arbitrators are lawyers, and they tend to rely on the rules of evidence as a guide when evidentiary disputes arise. Once the parties have completed presenting their evidence, then each side is provided the opportunity to make closing arguments to the arbitration panel. During closing arguments, the lawyers summarize the evidence that was presented and provide their arguments as to why the arbitrators should rule in their party's favor. After the hearing is over, the arbitrators meet privately to review the evidence and make their final decision. Once they have reached a decision, they will issue an arbitration award with a ruling on who gets what. Importantly, the final arbitration decision is binding and very hard to appeal or overturn. The grounds for doing so are very narrow, and courts rarely grant such requests. Presenting a persuasive case to an arbitration panel involves a tremendous amount of preparation, strategy, research, and expertise. If you have questions about the arbitration process, give us a call and we'd be happy to talk about it.